Hunter Biden has agreed to plead guilty to 2 tax misdemeanors and accept a plea deal on a separate gun charge, a move that will likely keep him from serving any time in prison. Local defense attorney and former federal prosecutor Curtis Fallgatter is joining us this morning to take a closer look at these charges. Good morning, Curtis. Thanks for being
Morning,
here.
Jenna.
I appreciate it. I just based on, so we know these first 2. I kind of want to unpack these charges if we could. So Hunter Biden has agreed to plead guilty to 2 counts of willful failure to pay federal income tax. And we're also hearing that the federal government is likely going to recommend probation for these tax crimes. Is that unusual?
Not really. You know, I was a federal prosecutor 17 years, and federal prosecutors almost always work on felony cases. This is a misdemeanor. A failure to pay, failure to file, those are misdemeanors. You don't prosecute this very often. You know, we used to call it like kissing your sister. It's not very rewarding. You want to go after felony cases. So it's not common to prosecute these kind of misdemeanors. Typically, they try to collect on them. So this is a little unusual.
So unusual that they would even consider prosecuting them.
Right, particularly since the taxes have all been paid back.
Yeah. So why might the government agree to probation then?
Well, for those same reasons. I mean, it's a misdemeanor, so those cases typically end up in a probation category. He paid all the taxes back a couple years ago, I understand, so that's another factor. And, you know, he's got the addiction problem, so that's a mitigating factor that they would consider. So that's another factor. I'll give you one quick war story. I handled a case years ago with a CPA that handled hundreds of filings a year for his clients. Didn't file for himself for 10 years, but he had an addiction problem. So IRS looked at that and they decided not to file anything. So those are some of the reasons why they would want to consider a probation sentence.
And that addiction problem, which Hunter Biden has been very open about having since his brother Beau died several years ago of brain cancer. How might that then be a factor, you know, with prosecution, that they just feel like they can't make that case because someone could say, well, I had an addiction problem and I just don't remember?
And it's a willfulness issue.
Yeah.
As you just read, it's a willful crime. You have to willfully fail to file if there's a reason for it, if you're in a coma, if you have addiction, you know, if you have some psychological issues. Those are reasons that willfulness is defeated, which is another reason a prosecutor could either not prosecute or at a minimum consider probation as the resolution.
So I've covered the courts for many years, as you know, been here for 25 years, and I did not realize until this yesterday that this third charge, which is the crux of this third charge, a felony for the gun possession, which is what many people now are referring to as kind of, you know, questioning whether or not this might be a sweetheart deal for Hunter Biden. So that's why I want to dig into this. So basically, federal law prohibits a firearm purchased by someone who has a drug addiction? I didn't realize that was a federal law.
Me either, not until a couple years ago. Jennifer, all of us know that a felon cannot possess a gun. If you're a convicted felon, you can't possess a gun. We all know that. But very few people, if any, know that if you have a drug problem, you can't have a gun, you know, for home protection. So 17 years as a prosecutor, we never prosecuted that type of case at all. I didn't know it existed. I saw it a couple years ago, so it's very rarely used. And again, another example as to why they might give him a PreTrial Diversion agreement, because again, it's not used very often.
Would you explain what PreTrial Diversion program is and
Sure.
how that will work in his favor here?
It's like probation, except it's a contract with the government. And the contract says you got to keep your nose clean, you can't have any other offenses. But of course, he's probably going to be placed on probation on the federal court case, so that PTI will probably run concurrently with the PTI. It's just a contract to not get in any more trouble, and if you don't, they'll drop the case.
And I hear this used all the time in state court. Is it just as common in federal court as well?
Not nearly as common in state court,
okay.
in federal court rather. In state court, it is used a lot. If you're a first-time offender, you're a very good candidate for pretrial diversion, but in federal court, they don't do it quite as often, in part because they don't have quite the mechanism in terms of probation officers to monitor that. So it happens, but not as often.
I mean, did he get a break here then? I mean, what's your take on this?
No, again, it's, you know, you're dealing with, people don't really know that's a crime, and plus, how do they prove it? You know, this is a case from almost 5 years ago. The statute of limitations would run in October, and they're alleged in possession for 12 days in October 5 years ago. The statute's almost run. So it's kind of a difficult case for them to prove. So PTI is an appropriate disposition for what is really a kind of a unusual statute that's not used very often.
Curtis, thank you for your perspective on this. We appreciate it.
My pleasure.